to 2 minutes.
Okay, thank you. My name is Ellen Katz. I'm a law professor and associate dean at the University of Michigan Law School. I'm speaking here on my own, in my personal capacity, not on behalf of the school. I'd like to thank the committee for the opportunity to be here and to Senator Alvarado for the invitation. I'll be discussing what you've already been discussing, which was the July 7th letter from the Justice Department, the formal notice it gave the state of Texas of serious concerns about these 4 districts that it calls coalition districts, which it doesn't define, but are generally districts in which the combined population of 2 minority groups constitutes a majority of the district. I'm going to make 3, I hope, quick points today. First, the letter asserts that the districts violate the Voting Rights Act. They don't. There's a recent judicial decision that you've already mentioned that holds that the effects-based prong of the Voting Rights Act, that's Section 2 of the Voting Rights Act, doesn't require Texas to draw these districts, but there's no authority whatsoever. There's no claim that the very existence of these districts violates the Voting Rights Act. The second claim the letter makes is that the districts are unconstitutional. And here, the gist of that claim is that the districts were drawn or otherwise reflect impermissible race-based considerations. They don't. Again, Attorney General Paxton's letter on July 11th cites the sworn testimony from the ongoing litigation that race was not considered whatsoever in drawing these 4 districts. They can't be unconstitutional racial gerrymanders or otherwise involve unconstitutional discrimination for that reason. And my last point is I want to say what I think is the most important one, and that is what this letter is instructing Texas to do. Were Texas to do it, would be illegal. The letter targets what it understands to be effective coalition districts, and then it calls on Texas to alter their racial composition to render them ineffective. The Supreme Court has made clear that dismantling districts in this manner is constitutionally problematic. And were Texas to do what this letter instructs, it would not only be injecting race-based considerations into what it says was a race-neutral process, but in so doing, it would be intentionally drawing district lines to destroy effective coalition districts. It amounts to intentional race-based discrimination, and I urge Texas to refuse to take such action.
Thank you, members. Any questions? Senator Hinojosa.
Thank you, Mr. Chairman, and thank you very much for your testimony. I do have a couple of questions as it relates to the Voting Rights Act and the Pettyway versus Galveston City case by the Fifth Circuit. As I understand, the ruling just applied to Section 2 of the Voting Rights Act, and it only dealt with an issue of whether or not coalition districts could make a claim under that the voters were being diluted by redistricting. Is that your understanding of the case?
Yes, I think that's exactly right. The claim, the holding of the court in overruling circuit precedent was that Section 2 of the Voting Rights Act, the effects-based or what we call the results-based prong of that provision, does not require Texas to draw the other states within the within the Fifth Circuit to draw coalition districts in the first instance. There's no obligation to do so. That's all it holds. It doesn't hold that coalition districts independently, the ones that exist, violate the Voting Rights Act. That's a astounding proposition. The mere fact that there's a district in which there are 2 minority groups with a population that is a majority, that's just that there's nothing problematic about that. And in fact, there are hundreds and possibly thousands of such districts throughout the country in which jurisdictions applying traditional districting principles draw districts, and the resulting districts have populations of this sort. The VRA has never prohibited that, and the DOJ letter is flatly incorrect in stating otherwise.
And in the ruling itself, anywhere in the body of the ruling, did the Fifth Circuit declare coalition district as unconstitutional?
Yeah, no, it didn't reach that question at all. I mean, and it didn't read the question whether the failure to maintain a previous coalition district would be unconstitutional. My understanding is the district judge didn't rule on those issues because he initially found a violation of the Voting Rights Act, and so that's the issue that went up, and that's the issue that the court held didn't require the drawing of the districts, which again is a very different question than whether the districts themselves are independently a violation of the statute.
And the court did not address the issue of violations of the 14th Amendment or 15th Amendment of the Constitution, as I understand the opinion.
It did not. I mean, and it's worth enough, if the committee is interested, we can spend some time on what the DOJ letter is saying about constitutional violations and why these 4 districts are, in its view, unconstitutional. These are, I mean, they are not. They're unequivocally not. The claims the DOJ are making are simply wrong.
And the ruling was pretty narrow just to the claim on the dilution of the vote by under Section 2 of the Voting Rights Act, and that's as narrow as it was.
Yes.
As I read the letter from DOJ, it seems to me that they have completely misrepresented and distorted the opinion, and are now targeting only minority coalitions and even minority majority congressional districts. Those, in your opinion, are those blatantly illegal under the Constitution?
I guess I want to say 2 things. No, they're not. The letter's assertion that these districts are unconstitutional is, in my view, flatly wrong. The letter is strange in that one would think the claims are not even close. It's not like, oh, we could have a debate about this. They are not unconstitutional. And one of the critical reasons is the Attorney General of this state's letter confirming that race was not taken into account in the drawing of these specific 4 districts. The letter, nevertheless, the DOJ letter, nevertheless, relies on the mere racial composition of these districts, looks at their composition and says, oh, there must be something wrong. They're unconstitutional, and in fact calls them unconstitutional racial gerrymanders. They can't be unconstitutional racial gerrymanders for the very reason Attorney General Paxton said. They were not drawn based on race. And racial gerrymander definitionally requires that the jurisdiction allowed race to predominate over traditional districting principles. That didn't happen here. These districts cannot be unconstitutional in that sense.
One more question, and that is the DOJ letter actually targeted Congressional District 9, 18, 29, 33, which all those congressional districts are either minority coalition districts or majority minority districts. Is that targeting of those congressional districts unconstitutional?
Yeah, I think it is, and I think your word targeting is exactly right, and it's why I think that for Texas to do what the Department of Justice is presently insisting that it does would be to itself violate the Constitution, to inject race into what has on the state's representation been a race-neutral process, and to dismantle effective coalition districts, majority-minority coalition districts, in which precisely because they are effective coalition districts. The letter, I mean, and we talked about this a bit yesterday at the hearing yesterday. The Supreme Court has said, don't do this. And this is the Bartlett versus Strickland letter. And we can get a little bit into the weeds decision, and we can get in the weeds talking about the difference between crossover districts and coalition districts. But the gist of that opinion, or on the relevant point of that opinion, was the Supreme Court, in talking about what the Voting Rights Act requires of jurisdictions, also said the following, and I'm just going to read the court's words. They said, whatever Section 2 might require, if there were a showing that a state intentionally drew district lines in order to destroy an otherwise effective, they're talking about crossover districts, you can sub in coalition districts here, that would raise serious constitutional questions. And that's precisely what the DOJ letter is asking, or instructing Texas to do what Bartlett said don't do. It targets what it understands to be an operational coalition district, and it calls on Texas to alter its racial composition so as to destroy them, to dismantle them, and make them ineffective as coalition districts. And the Supreme Court has signaled that is unconstitutional behavior.
Thank you, Mrs. Katz, for your testimony.
Senator Miles.
Thank you, Mr. Chairman. Attorney Katz, I want to thank you for making this plain and clear. Having 3 partially or wholly in my district of these congressional districts that are targeted by DOJ, you've made it in the Supreme Court case of Bartlett and Strickland, and you've made it very simple to understand and how it applies to this particular incident. So I want to thank you for that, ma'am. Thank you.
Senator Alvarado.
Thank you, Mr. Chairman. Ms. Katz, we appreciate you attending both hearings, both in the House and here. You mentioned the Bartlett-Strickland court case, and I said this earlier that I don't want to be a part of anything that is unconstitutional. And we have, court cases. We have the Supreme Court telling us, and there's precedence for this being unconstitutional. So with that, and let's look back to what took place in the 2021 redistricting process, where it was said many times, whether it was in hearings or on the Senate floor, that the maps were legal, constitutional, and in compliance with the Voting Rights Act. Even if the DOJ letter were correct, the state claimed here and at the trial, which was very recent, that the current maps were drawn without regard to race, and the maps were adopted in 2021, changed the districts listed in the DOJ letter substantially. What significance does that have?
I think it's entirely dispositive. There cannot be the violations that the letter is suggesting if the state drew these districts without consideration of race. The Constitution requires intentional race-based intentional discrimination to be a violation requires that. The state has insisted that's not what it has done. There's no evidence, at least with regard to these 4 districts, that race was considered in any way when they were drawn. We have sworn testimony on that effect. They can't be unconstitutional or race-based unconstitutional conduct for that reason. And the same for the Voting Rights Act. It can't, the intentional discrimination will also violate the Voting Rights Act. It cannot be the case here because of the way the districts were drawn.
Do you have any idea why the DOJ would send such a letter and target those particular congressional districts?
Yeah, that's not something I can speak to. I have only read the letter like you. I read that letter. If my students wrote that letter, I would give them a bad grade because it's a bad assessment of what the Voting Rights Act requires. It's a bad assessment of what the Constitution requires. The facts that we know make the claims that the conclusions it's asserting to be wrong. It's not close. There's not like, we can have a debate about that. There is, given the representations from the state, the legal claims that the letter makes simply do not hold up, and instead I think forces us to look at what the letter is in fact instructing Texas to do, whatever its intent. What the letter is instructing Texas to do is to dismantle these districts that were drawn, as Texas has said, in a race-neutral manner, and to do precisely what the Supreme Court in Bartlett versus Strickland said, that raises a huge constitutional problem. And that was not what they were talking about in Bartlett. That was not what they were talking about in the Fifth Circuit of the Petaway case. It's something else entirely.
Well, and you hit some core points, is that, I wish the leadership in this state, and we have, an attorney general, we have many lawyers in this building that should have nipped this in the bud and said, stop, we're not going any further because what you're asking us to do is unconstitutional. But yet, here we are. Thank you.
Just one question.
Senator Miles.
Ms. Katz, you stated that doing a map now would be illegal. Can you expound on that one more time for us?
So I think I have to say something more precise than that. Leaving aside drawing the map for any other reason, redrawing these districts for the reasons the DOJ letter instructs would be, in my view, illegal. So that's the claim I want to make.
Okay. Thank you.
Members, any other questions? Just one quick one, Ms. Katz. Did you provide testimony in the El Paso case?
I did not.
Were you part of the plaintiff's team or one of the plaintiff's attorneys?
No.
Okay. Thank you.
Not anyone.
If there's no other questions, members, thank you for being here with us today, ma'am.
Thank you.
Chair calls Gary Bledsoe and Mr.